So what we're going to talk about today, if we'll just flick that first slide up, is obviously the termite damage. It's insidious. It can cause great expense to the body corporate, the lot owner, or both of them. And in my experience, the damage is often seen when it's too late to do anything about it, and when the necessary repair costs become exorbitant. So when we get questions about termite damage, the question generally is, well, I've suffered termite damage, who's responsible to fix it? As I said, there's no definitive answer, that the case law doesn't provide us with a definitive answer, but we're down to, obviously, is it the body corporate's responsibility to fix the termite damage suffered to a lot, or is it the lot owner's responsibility to fix termite damage suffered to a lot? Of course, if the termite damage is to the common property, then more likely it's going to be the body corporate that is responsible for repairing that damage, unless the body corporate can prove that the termites emanated from a lot, and therefore the body corporate might have recourse against the lot owner. So for the purposes of today, we'll discard the obvious answer as to who's responsible for termite damage, being the termite, and that leaves us with the body corporate or the lot owner, or indeed a combination of both. Now, notwithstanding that I've said there's no definitive answer as to who is responsible for damage, there's obviously a starting point that we must consider, and that starting point, like most matters body corporate, is the legislation. Now, as you will know, we're governed by the Body Corporate and Community Management Act, and within that act we're governed by the various modules. I assume most of you here today, your schemes will be governed by either the standard module or the accommodation module. So if someone says to me, I've suffered termite damage in my lot, or a body corporate comes to me and says a lot owner is making a claim against us for termite damage, where do I go to first? And well, I go to the legislation, and the first point of call for me is section 159 of the accommodation module, which is already up there. So I won't bother going through it in detail, but the important point is that the body corporate must maintain common property in good condition, including to the extent that common property is structural in nature, in a structurally sound condition. And then there's various rules with respect to where your scheme is created under what's called a building format plan. And look, I won't go into it in detail, but just for the purposes of today, building format plans, if you think about it, buildings that go vertically are generally created by a building format plan, and your classic gated community is generally governed by or created by a standard format plan. Now, the main difference between both of those plans is that in a building format plan, the lot owner is generally responsible for everything within the inside of the lot, so within the walls. In a standard format plan, it's generally the case that the lot owner is responsible for everything within the boundaries of the lot, and that boundary might extend beyond the walls. You might have for example, a backyard, front yard, two side yards, and a little townhouse in the middle. So that's where I go to first to say, okay, there's damage. Is the damage to the common property? And then if it's in a building format plan, I need to ascertain whether the damage is to any of those other items within the lot, which, pursuant to this legislation, the body corporate is responsible for. So if there's damage to doors, windows, railings, roofing membranes, although termites are unlikely to damage roofing membranes, but they can damage foundation structures, certainly can damage essential supporting framework, I need to go through that list and determine, based on where people tell me the damage is, whether under that legislation it's likely to be the body corporate's problem or it's likely to be the lot owner's problem. Now, having said that, we then go to section 170, which places obligations on an owner. Now, the fundamental obligation on an owner is to keep parts of the lot readily observable from another lot or common property in a clean and tidy condition, and importantly, the owner of a lot included in the scheme must maintain the lot in good condition. Now, there has been case law which says maintaining a lot in good condition includes undertaking regular pest prevention and maintenance routines. So if an owner doesn't undertake regular pest prevention and regular pest inspections, then arguably they're failing in their obligations under section 170 of the standard module, and there'll be a complementary section under the accommodation module. Now, how then do these statutory legislative provisions translate to termites and bodies corporate? Well, irrespective of the type of scheme, so irrespective of whether it's a building format plan or a standard format plan, in my view, the body corporate must at least have a termite prevention plan in place, including a termite barrier, and the body corporate must maintain a regime of rigorous and regular inspections, at least annually, in my view. Now, that means that at come budget time, the budget should include a line item for if you don't have a termite barrier, for getting a termite barrier. If you do have a termite barrier, it should be a line item for regular, at least annual inspections. If an owner has suffered damage to its lot, and I'm trying to establish whether that damage could be the responsibility, or repair for that damage could be the responsibility of the body corporate or the owner, one of the first things I'm going to look at is the body corporate budget to see whether those line items that I've just spoken about have been included in the budget. For those of you that are on committees here, there is nothing worse when you're lodging a submission on behalf of a body corporate in response to a claim by an owner that the body corporate's responsible for termite damage. There's nothing worse than looking at the budget, seeing that there's a line item for annual inspections, and then learning that no annual inspections have been undertaken. So from the body corporate's perspective, it is absolutely critical, in my view, to defend any potential claim against the body corporate that it's got a termite barrier, and also that those regular inspections are undertaken. From an owner's perspective, an owner's got to take some responsibility for termites. It simply cannot be left up to the body corporate for them to do their inspections, for them to put in a termite barrier, and then for an owner to say, well, I'm on the 13th floor of a body corporate, of a building format plan, or I've got a standard format plan, it's not my responsibility to undertake termite inspections in my own lot or termite prevention measures in my own lot. As I said before, section 170, by virtue of an owner having to be responsible for the maintenance of its lot, is also responsible for a reasonable pest prevention plan, and that's been borne out in the adjudication decisions. Now, in my view, and it's going to sound common sense, or I hope it sounds common sense, having the common property and the lots inspected has to be a win-win for everyone involved. If the body corporate has their common property inspected at least annually, if lot owners have their lots inspected at least annually, then obviously that should reduce the potential for termite damage. Now, conversely, if the body corporate has a termite barrier and regular inspections and the owner does not, then as I said earlier, it's a good chance that in those circumstances the body corporate would successfully defend a claim, or indeed successfully prosecute a claim against an owner for damage caused to the common property. If we look at now the scenario that tends to come across my desk, we have an owner that discovers termite damage to its lot. The owner obtains a quote to fix the damage and either gets the damage fixed and seeks reimbursement from the body corporate, or seeks funds from the body corporate in the first instance in order that the owner might then proceed to get the damage fixed. Now, these claims can sometimes run into the tens of thousands of dollars. We've had one recently where the claim against the body corporate from memory was $44,000. I've had some where the claims have been in excess of $50,000. So when we're talking about that sort of money, owners tend to want to try and lay blame, rightly or wrongly, at the feet of the body corporate. Now, the body corporate often will deny responsibility for the damage in the first instance. What rights then does the owner have? Well, the owner can either accept the body corporate's position, or what happens more often than not is that the owner will lodge an application in the Commissioner's office seeking an order that the body corporate is liable for the damage. When that happens, so when an application has been lodged seeking orders that the body corporate's liable for the damage, the body corporate of course gets the right to lodge a submission in response to that application, to essentially plead its case. Now, normally they would engage a lawyer to draw that application, so obviously there's a cost involved in the body corporate defending any application that may be made against it. So, to my mind, the first question really is not a legal one. The first question is a commercial question, and that becomes, is it economically viable for the body corporate to defend the application? So putting aside the principle of the matter, who's right and who's wrong, you've got to put that economic hat on and say, okay, if the claim is for $5,000 and it's going to cost the body corporate $6,000 to have a lawyer lodge a submission, is it economically viable to get the lawyer to lodge that submission? Or do we go back and say to the owner, no, look, notwithstanding we don't believe we're liable, we're going to pay you the $5,000, or we're going to pay you $2,500 and you kick in $2,500. So depending on the size of the claim, in my view, the body corporate acting prudently really just needs to do the maths. That said, I recently had a body corporate where the claim was for $1,358 from memory. I told the body corporate, essentially as a matter of commerciality, pay the owner $1,358. Foolishly, I said, don't pay me $5,000. Thankfully, the body corporate said, no, if we pay this owner $1,358, then every other owner is going to come to us and claim that their damage is the responsibility of the body corporate. So that $1,358, I took instructions to lodge a submission, and I'll talk about the specific scheme shortly. But we took instructions to lodge a submission. I think to lodge the submission, or to prepare the submission, was in the realm of $3,000 or $4,000. So clearly exceeded the amount of the claim, but on that occasion the body corporate formed the view that it was worthwhile getting an order in their favour, and we had no guarantee at that time that we would get an order in their favour, because as you may be aware, going to the Commissioner's office is a bit like tossing a coin. You really don't know what the outcome is going to be. But notwithstanding my advice that it was more prudent to simply pay the applicant what they were claiming, the body corporate instructed me to lodge a claim and see whether we can defeat the application, essentially to send a message to the other lot owners. Now, if an owner lodges that application, then for an owner to be successful, the owner must essentially show that the termites entered from or passed over common property, and or the body corporate is the cause of the damage because it was derelict in its duty to repair and maintain common property. Now, the onus of proving that is on the applicant. So there's been many a case where the applicant has simply said, no, it's the body corporate problem, I don't have termites in my lot, so therefore it must come over or from common property. And adjudicators have been willing to throw those claims out because they've simply not provided any evidence to the Commissioner that the termites came in or over common property. I'm not a pest controller. My understanding is termite nests can be hundreds of metres away from the scheme land. Termites can fly in, termites can come in furniture that might be around the pool, termites can come in a pot that someone might put on their balcony. So it's often difficult to determine exactly where the termites came from. But irrespective of that, it's on the applicant's shoulders to prove that the termites either came in or over the common property, or that the body corporate was responsible for the damage that was suffered to the lot. Now, it's going to, of course, be somewhat easier for an applicant, for a lot owner, to make out their case where they can go back through the records of the body corporate and ascertain that A, there is no termite barrier, or if there is a termite barrier, that it hasn't been maintained, or that the body corporate hasn't been undertaking or causing regular inspections to be undertaken. So it's absolutely essential, in my view, for those of you that are on committees, that you make sure you've got those termite barriers and a termite prevention plan in place, so that if a claim is made against the body corporate, at least you've got some leg to stand on. Now, in my view, that there is some case law that adequately sums up where we stand with respect to termites. Now, I'm not going to bore you with every detail of the cases, but it's worthwhile to check out some pertinent comments from recent decisions. As I said though, there is no consistent flow in decisions that have been made by the adjudicator. The case I mentioned before, I thought, based on the facts as they were relayed to me from the body corporate, that we had no chance in Hades of being successful, but lo and behold, we got the order and the body corporate was found not liable for the termite damage. So the first decision I want to take you to is Surface Green, which is up there. Now that's a 2012 decision, and you'll be able to read the pertinent material from there. Now, what I want to say is that pursuant to section 280, if damage has occurred to a lot because of a failure to maintain or rectify a defect in something that is the responsibility of the body corporate, then the body corporate would be responsible for rectifying that damage. So that just goes through or reinforces what I've said earlier, is really what the adjudicator is trying to find is who's at fault. And the body corporate will be at fault if evidence can be established that it has failed to comply with its statutory obligations to repair and maintain common damage. So, common property. So while an owner is generally responsible for the interior of a lot, a body corporate will be liable to rectify any damage to the inside of a lot arising from its failure to effect adequate pest prevention. So again, we're just looking to ascribe fault to the person who caused the damage, and if we can establish, if an owner can establish that's the common property, can establish that's the body corporate, then the body corporate will be liable to repair that damage. Now, in that case, in Surface Green, the body corporate was indeed held liable for the damage to the lot because it failed to maintain the common property by implementing an effective termite protection plan. So again, that's what the adjudicator is going to look to. That's what lawyers acting for body corporates will look to, and no doubt lawyers acting for lot owners will also look to see whether the body corporate has maintained that termite prevention plan. The next case I want to discuss is a 2015 case, which is the Silver Pine Villas case. Now, this is the case that I was talking about earlier, where for the life of me, I thought that the body corporate had absolutely no chance. I can't remember the exact figure, but it was around the $1,280, $30 mark, something like that. Ultimately, in the case, there was damage to a roofing membrane, and there was also termite damage, damage to roofing truss and membrane, and there was also damage to interior walls. Now, the body corporate had a termite barrier put in, I think, in 2010. Then it had some fairly regular inspections up to 2013. Then the inspections seemed to drop off, and the damage was reported in 2014. I was concerned for the body corporate because they had not maintained those regular inspections. You know, the inspections dropped off, and the damage was discovered post the last inspection. Now, at paragraph 24, the adjudicator said that a body corporate is required to act reasonably in performing its functions. Now, every decision a body corporate makes pursuant to the legislation must be a reasonable decision, and that's enshrined in the legislation, that everything a body corporate does, it must be acting reasonably. Now, what the adjudicator said in Silver Pine, that in performing its functions, the body corporate does so if it has a system in place for monitoring the maintenance or state of repair. The adjudicator was not satisfied that the body corporate had failed to implement reasonable termite prevention and control measures. So essentially, in this decision, the applicant was slapped on the wrist because it had simply failed, the applicant had simply failed to provide any evidence of the steps the applicant had taken to ensure the interior of his lot was free of vermin and insects. So, notwithstanding, in my view, the body corporate didn't strictly comply with the prudent course of action to have regular inspections. Those inspections dropped off in 2012 or 2014. Because the applicant himself in this case didn't have its own pest inspections, then the applicant was found not to have made out its case that the body corporate was responsible for the damage. Of the $1,300 odd that was claimed, in this case the body corporate was ordered to pay $300 for damage to the roof truss. That was attributable to a fault in the waterproofing membrane, which it seems to be fairly settled law now that if there's a defect in a waterproofing membrane, the body corporate's going to be slogged for that. With respect to the damage to the wall that was allegedly caused by termites, the body corporate was held not to be responsible for reimbursing the owner for those damages. So I think what comes out of that case is the critical importance of a lot owner either undertaking their own termite inspections or at the very least, and it's probably the more effective way to do it, is when the body corporate is getting the common property inspected for termites, see if the lot owners can arrange for access to their lots all on the same day so that the body corporate's inspector can also go in and inspect the lots. If a lot owner doesn't allow access, and if a lot owner then doesn't undertake their own pest inspection and that lot owner suffers damage, then in my view that's going to weigh heavily against the lot owner being successful in any claim he or she may have against the body corporate for termite damage. The next decision is a really recent one, at Ridgeview Terraces, February 2015. Now, the pertinent topics out of, or pertinent comment out of those is paragraphs 22 through 32. And for those of you that are having trouble sleeping, have a read of Ridgeview Terraces, because within paragraphs 22 to 32, and it happens very rarely that an adjudicator will adequately set out the state of the law, but in this case, to the adjudicator's credit, that's exactly what the adjudicator has done, and there's a fantastic summary for all of you that might be interested in, not just with termites, but body corporates and owners' obligations with body corporates' obligations with respect to repair and maintenance of common property, and owners' obligations with respect to the condition in which they must maintain their lots. So I won't bore you today, given the time constraints, of going through paragraphs 22 through 32. If we can just... Oh, yeah. My partner in crime's left me.
Again?
Yep. No, that's fine. Sorry, go back.
Yep.
So the really important things to take out of that case, firstly is again the applicant was unsuccessful in that the applicant didn't provide or make out a sufficient case that the body corporate was derelict in its duties, and therefore the applicant was found responsible. The really important thing to come out of that case though is this. The applicant was claiming, I think, $50,000 odd, $50,500 or thereabouts. Now, under section 281 of the legislation, there is caps on what an adjudicator can order. If an applicant if a lot owner is making a claim for damage, then the cap is $75,000. If the lot owner is paid to have that damage repaired and is seeking reimbursement from the body corporate, then I think the cap is $10,000. What this case says, and to be honest I'm not sure that I agree with it at the moment, is that there is a fundamental right vesting in the Commissioner's office or a Commissioner to make an order which is just and equitable. And what this case says, and this is relevant for not only termite damage, but what this case says is, irrespective of those caps placed upon the applicant and the body corporate under section 281 of the Act, that if it's just and equitable to make an order on ordering payment of money which exceeds those caps in the legislation, then the Commissioner's office has jurisdiction to make that payment. As I said, I'm not convinced of that, because to my way of thinking, well, what's the point of having the statutory provision of section 281, which sets these limits in statute, if the adjudicators are just going to turn around and say, oh yes, but it's just and equitable to award a different amount above and beyond what is set out in section 281. So that's a very, very important decision in terms of the application of this just and equitable right that commissioners have with respect to any application made by an owner. Essentially what the Commissioner is saying is, we have the right to make an order that is just and equitable in the circumstances. So, in summary, with respect to termites, I think what we really need to take home, everyone likes to have a take-home message, is that body corporates simply must budget for and undertake termite prevention plans. Owners simply must have their lots inspected, because they are the things that people are going to look to when we're trying to ascribe fault for any termite damage that's caused to a lot in a community title scheme, be it in a building format plan or in a standard format plan. So I hope that answers some of your questions. As I said, you're not going to get a definitive answer because it'll depend on the various nuances of each case. But I hope I've given you today some guidance as to responsibility for termite damage in bodies corporate. So thank you for your time.